Jenny Finn is an 8th grade student who recently moved to the Mountain View School District. While attending school in her former district, Jenny had a history of minor behavioral problems. She often disrupted class with jokes and she skipped classes. Jenny's most recent standardized test score results place her in the lowest quartile of all students in the state, in both reading and math. Her parents spoke with the school principal in her prior district on several occasions, wanting to know why Jenny was not performing well. Her mom even wrote a letter asking that the school do something to help Jenny succeed. The principal informed Jenny's parents verbally and in writing that Jenny was simply a below-average student and her problem was that she did not focus while in class. Prior to moving to the new district, Jenny's mom schedules a meeting with Mrs. Conrad, the principal of the school Jenny will be attending.
Hello?
Oh, hi, Mrs. Finn. How are you?
Very well.
I'm Mrs. Conrad. It's nice to meet you. I appreciate your coming. Please, It's always a pleasure to have a parent stop by, especially a new parent.
Thank you so much. You know, I really appreciate your meeting with me today.
I hear your daughter's going to be an 8th grader.
Yes, she is. I really wanted to speak to you today because I wanted to tell you a little about Jenny. At Cross Creek, she had some problems. She struggles with her studies, and sometimes she can be a bit of a cut-up in class, which has gotten her into trouble. But I really felt like the school could have been doing more for her. I went many times. I even wrote letters, and some of her teachers would tell me that she needed extra help.
I promise to keep a close eye on Jenny, Mrs. Finn. I'll make sure her teachers give her any help she needs while here in Mountain View.
3 weeks after Jenny started school in Mountain View, Jenny's parents were called in to meet with the principal. Apparently, Jenny had been involved in a fight with another student.
Mrs. Finn, I've been following Jenny's progress very closely since she arrived here. I know that her teachers, and especially her math and language arts teachers, have been spending a lot of extra time with her. They've been tutoring her after school. We all thought she was making real progress, but yesterday, Jenny got into a fight with another student. I interviewed quite a few witnesses, along with Jenny and the other student involved, but from what I learned, it was a very serious physical altercation, and Jenny seems to have been the initiator. Given the seriousness of this incident, the district is considering a long-term suspension for Jenny.
I told you I thought Jenny had some issues. That's why I wanted you to keep an eye on her. I think she might need to be evaluated. She might have a disability. And by the way, I talked to some lawyers, and they told me that if Jenny has a disability, you can't punish her.
I agree that we can look into the issue of whether Jenny has to be classified. But that has nothing to do with this fight. That's a separate issue. You'll be hearing from us. If we pursue a long-term suspension, you'll first receive a notice, and then we'll hold a hearing.
As far as I'm concerned, you can't do anything to Jenny until you evaluate her.
In the scenario you've just watched, Jenny is an 8th grader who experienced minor behavioral problems in her former district and had a major fight with another student in her new school. She's had low achievement in math and reading. One issue this scenario raises is whether the new school district was on notice that Jenny should be referred for an evaluation of eligibility for special education and related services. School districts are deemed to have constructive knowledge that a child may have a disability when a parent requests an evaluation. The same is true when that concern is expressed in writing to a teacher or administrator. If a school district is considered to have had either actual or constructive notice of a student's disability at the time an incident occurs that would otherwise warrant disciplinary action, then the student's entitled to all due process protections available to special education students, even though the student was not classified at the time of the disciplinary incident. Before they moved to a new school district in this scenario, Jenny's mother alerted the principal in the new school to difficulties that Jenny had experienced in her previous school. Her mom also told the principal that she had requested that Jenny's old school, quote-unquote, do more for her. The initial conversation that Mrs. Finn had with the principal alerted the principal that Jenny was having academic difficulties, but not necessarily that Jenny had a learning disability. Mrs. Finn's request for an evaluation after the fight put the school on actual notice that Jenny was potentially a child with a disability. Under the reauthorization of IDEA, Mrs. Finn's expression of concern were not sufficient to put the new principal on constructive notice that Jenny should be evaluated for eligibility for special education. In this scenario, the school acted reasonably in providing extra tutoring for Jenny in her first few weeks in her new school. Since the school district did not have knowledge of Jenny's potential disability before the fight, she was not entitled to the protections of special education law. If the school had received actual or constructive notice of Jenny's disability, then Jenny would have had the right to those protections available under special education law, which include limiting suspensions to 10 school days unless a manifestation determination is conducted. Another issue depicted in this scenario is the appropriateness of the proposed discipline for Jenny, which was a long-term suspension. Long-term suspensions are those suspensions that occur for 10 school days or more. All students who are disciplined with a long-term suspension, whether in regular education or special education, are entitled to notice of the reasons and a hearing before a board of education prior to being suspended. In addition, students receiving special education generally cannot be suspended for more than 10 school days without the district first conducting a manifestation determination. If a student's fighting was caused by or related to a disability, then the conduct was a manifestation of that disability, and generally the student cannot be suspended for more than 10 school days. In addition, a student's behavior is also considered a manifestation of the student's disability if the behavior is a result of the district's failure to implement the IEP properly. If a student's behavior is a manifestation of a disability, the student may only be suspended for more than 10 days in one of three situations. 1, if the incident involved possession of illegal drugs. 2, if the incident involved the use of weapons. Or 3, if the student caused serious bodily injury to another person in the incident. When a student is suspended for behavioral issues, a functional behavioral assessment must be done to develop a behavioral intervention plan. Another issue in this scenario is the so-called child find obligation under special education law. The child find obligation requires every public school district to identify, locate, and evaluate all children with disabilities residing in their district. A practical method must be devised to determine which children with disabilities are currently receiving needed special education and related services. New Jersey regulations state that the type of disabilities to be identified include physical, sensory, emotional, communication, cognitive, and social difficulties. As part of school district's child find responsibility, interventions must be provided in a general education setting for students exhibiting academic difficulties. Jenny's teachers did provide additional tutoring for her. Although the new school failed to identify Jenny until after the fight occurred, it appears they acted reasonably for the most part in regards to their child find obligations by providing Jenny with additional academic supports. We do not know if they complied with another requirement, that teaching staff members must maintain written documentation of the interventions, their frequency and duration, and their effectiveness. When the intervention has not addressed the educational difficulties adequately after a reasonable period of time, and it is believed that the child may have a disability, the child must be referred for an evaluation for eligibility for special education. In this case, the academic supports had only been tried for 3 weeks. Given this short time period, it appears the district simply did not have sufficient information at the time of the fight to be placed on notice that Jenny may have a disability and should be evaluated. The scenario we've just seen addresses school districts' obligations to act on knowledge of a suspected educational disability and to find children who are suspected of having a disability. The scenario also addresses how to determine what discipline is appropriate when a student assaults or injures another student, particularly when the harmful behavior may have been a manifestation of a previously unidentified disability. Other issues of special education law are addressed in additional Legal One videos. The Legal One website has many resources for you to consult to gain a fuller understanding of special education law.